WTDY, and now back to Sly in the Morning.
9:06 now, Sly in the Morning. Lawton and Cates joining us once again. Dixon Gahnz and Kent Carnell. They want to talk a little bit about that term that we talk about here on this show from time to time. Well, you'll often see it on Tea Party posters, tort reform. And most people don't really know what it is, do they, Dixon?
Well, I don't think they do. First, it's the idea that we have to have a crisis, and so you have this civil justice or this litigation crisis that really just doesn't exist in Wisconsin. And then once you gin up a crisis, you have to come up with a solution to take care of it. And the solution is to curtail the rights of people that have been injured and people that and block the access to courts.
Was there anything in this bill, Kent, that actually gave a litigant more power to take on a powerful corporation?
No, everything was taken away or reduced in terms of how much you could recover in punitive damages, taking away rights in nursing home type cases, making it more difficult to sue if there's a defective product, such as it makes it very difficult to sue the manufacturer of a product that is sold, maybe it's manufactured in China, sold by a company in the United States, such as Walmart, and you can't sue Walmart, or makes it very difficult. You can only sue the manufacturer in China, which for practical purposes may mean you can't recover.
That's an odd definition of reform, isn't it?
It's a very odd definition. Really what it is giving big business more power and taking away the rights of individuals who are harmed in some way.
Let me give you for instance, in the nursing home context, and this just strikes me as is unfair. You can no longer, if your mom or dad is in a nursing home and they've been abused or they've been neglected, and the state comes in, does an investigation, and finds violations of various state laws, regulations, and so forth, you can no longer call those state investigators to the trial. And it's worse. Not just the civil trial, but let's say that the abuse is so bad that your local district attorney says, this is a crime. You cannot use those results in a criminal prosecution.
You can't use the results from the state investigators.
And you can't call the state investigators to testify.
I'm guessing there's going to be a constitutional challenge on that one. Would there not be?
It's possible, but it's, the issues are kind of dicey in terms of how you go about. You can make the claim from the state's perspective that you don't want to have those investigators' time being used in private matters as opposed to their job, which is investigating.
Kent, was there a rush on suing nursing homes in Wisconsin?
Well, I think there's been more cases in recent years than there had before. But again, the change in the law is to benefit nursing homes and make it more difficult to sue them when they have injured one of their residents, either by not feeding them, not caring for them, they have pressure sores, things like that. It just makes them very difficult to sue them. Again, it's a change so that it helps business interests and hurts the individual rights of people.
What's the rationalization for this? I find it so hard because really when somebody has to put a parent in a nursing home, these decisions are not based on an ideological basis. Conservative Republicans have elderly parents and so do liberal Democrats. I can't possibly fathom that the nursing home lobby is so powerful in this state that these Republican legislators wouldn't be thinking about their own parent.
I think it goes to the culture where there's this idea that there's this lawsuit abuse out there and that you've got to protect business. And it's not, they've protected business across the board in these bills. In the insurance industry has been protected, various manufacturers have been protected. So it's just more of a continuation of that policy as opposed to, a real special thing just for the nursing home lobby. However, they certainly got a plum deal.
Right. Ken Carnell and Dixon Gahnz with us from Lawton and Cates. What's your phone number at Lawton and Cates?
282-6200.
All right. Is this all the more important that if you do have a case that you hire experienced lawyers that are able to figure out some of the nuances of this law? And I take it these are all obstacles, but there are some things you can do to still go after a nursing home.
Oh, absolutely. I mean, you still have the ability to go into court. The difficulty is going to be proving your case, and that's really there's two things that portion of the bill is designed. The other aspect is that they've limited the damages that you can recover.
200,000.
No, it's the wrongful. If a nursing home causes the death, then it's $350 for your mom or dad for the wrongful death, and then there's non-economic damage cap, which is around $750, which is somewhat tied to the inflation index.
So that's what a human life is worth, huh?
It is, and that's the wrongful death caps for children are $500,000 and $350,000 for an adult, and that's not just tied to nursing home. That's just across the board in Wisconsin.
Why do I think that they had these written long before they took office? Because there's a lot of stuff here.
Well, one thing, the mantra that's been talked about for a number of years is get rid of frivolous lawsuits. And if you think about it, one, I would say there are really not frivolous lawsuits in Wisconsin. And two, if it's a lawsuit of the kind they're talking about, it's taken by a lawyer that's on a percentage or contingency basis. He doesn't get paid unless he wins. And any good lawyer is not going to take, by definition, a frivolous lawsuit because he's going to lose. He's not going to win the case, and he may get attorney's fees of the other side against him as a sanction. So it just doesn't make sense to say there's all these frivolous lawsuits out there.
Well, and judges have the ability to do summary judgment, right?
Absolutely.
Okay. So as far as medical malpractice, we've had a good system in Wisconsin for a long time where there's only a few a year, and
Right.
that there's a compensation fund that makes insurance affordable for doctors to have, right?
Right.
Correct. The statistics are doctors and premiums for malpractice insurance are the second or third lowest in the country.
Let me just ask you quickly before we go here, this whole idea of that if you buy a defective product, you buy a toaster that shocks you and you get a severe electrical burn. This will make it tougher to go after the retailer that sold it, even though they very well didn't do any due diligence to test out the safety of that product. And you have to go after the manufacturer. And, of course, since very little is manufactured in the United States anymore, you'd have to literally try to go after somebody in a foreign country?
Correct. And that's really the idea was in the old law was that if you profited from the sale of the product, which Walmart and your Target and your other big retailers did, was that you were responsible if that product caused harm. They've taken that away, and they've said the only person that's responsible is the manufacturer. And there is I'm going to call it a small hole, a small loop that if you can get or if you can show that there's no way to get to the manufacturer, then you can possibly go after the seller.
This was all done in special session. This was an emergency that they did this for the state's economic climate. I noticed the first Walmart is actually going into the city proper in Milwaukee, and they just built a new Target over here by Hilldale. Has our product liability laws really stopped retailers from coming into the state? Does this really have anything to do with some sort of economic peril in the state of Wisconsin?
Well, the numbers say no. The numbers say absolutely not. Of the lawsuit filings in 2009, product liabilities were 0.0003. So 104 total cases in 2009. And interestingly, WMC did a poll of 600 CEOs about lawsuit abuse, and they all had talked about it. But when they were asked to rank problems facing their company, lawsuit abuse was last.
Kent, there's also a 15-year statute of limitation on product liability cases.
Yes, that's a change. It used to be if a product was manufactured many years ago, the statute of limitations would run from the date you were injured. It still does, but what it means now, if the product was manufactured more than 15 years ago, essentially you can't sue for that defective product.
And one more question. What is contributory negligence?
That's the negligence of the injured person. And in Wisconsin, if the injured person is more than 50% responsible for the injury, then they cannot recover, and that's under any of the legal theories.
Boy, they made that hill a little higher, didn't they?
They did, and the real tragedy is that it does two things. One is that people that have been injured are going to have a more difficult time getting their day in court, and the elderly, the worse the abuse is, with these caps, those people are now going to be undercompensated.
Well, on that happy note, gentlemen, Dixon, Kent, thank you for coming out. Want to give me your phone number for Lawton and Cates one more time?
Sure. It's 282-6200, and the website is lawtoncates.com.
It's LAWTON.
Correct.
CATES. All right. Gentlemen, thank you for coming out.
Thank you.
Appreciate it.
Thank
It's
you, Sly.
9:17.